all of a sudden, the issue of public workers and them campaigning for office while remaining a part of the public service is unconstitutional, is what some legal experts are saying. There was an article published on the weekend in the Gleaner which spoke to Dr. O.J. Dixon, who lost to Robert Morgan in North Central Clarendon. And we heard that the article written by Erica Virtue got views from two attorneys, Matondo Mukulu, the former acting public defender here, good chap, very good chap, and it heard from John Clark as well, the chairman of Jamaicans for Justice and a prominent attorney, both questioning the constitutionality of requiring public servants to avoid getting caught up in election matters. In other words, public servants are not supposed to seek political office while still being in the public service. We accepted that as the rules dictated that was the case. So we never thought before now that was an issue. But all of a sudden, we're being told that the arrangement and the rule, it may be an unconstitutional rule. And so the lead story in the Gleaner yesterday, the headline, interdicted, and it says, a junior resident at Maypen Hospital who contested the September 3 general election as a PNP candidate is set to face disciplinary proceedings on Monday, which is today. And the Gleaner says it obtained a letter bearing the signature of the director of HR Management and Development, which informed Dr. O.J. Dixon that he has been interdicted in accordance with the staff orders for the public service. As I noted, the article quotes Mukulu, who says, the staff orders are beyond legal authority in light of the Constitution. He says, the staff orders will not and cannot pass the constitutional test set by the court in Julian Robinson versus Attorney General because, as it relates to the use of interdiction, with its adverse impact on a person's salary before culpability is established, it cannot be shown that interdiction is a proportionate tool. Why would it be necessary to suspend a doctor or surgeon to investigate whether he or she has breached Regulation 4.2.6 of the staff orders? Mukulu reasons. He further argued that while the intention behind Regulation 4.2.6 may be understandable, the legal learning on provisions of this kind throughout the Commonwealth informs us that a blanket restriction, irrespective of the rank of the public servant, will fail the proportionality test. John Clark was even more blunt, the Gleaner says. The rule is unconstitutional. The article cites a Barbados High Court case in 2023, which struck down a regulation nearly identical to Jamaica's, and it even referenced another country. I'm trying to find it here in the article. But suffice to say that this article has served up some considerations that I never had in my mind before. It speaks to the regional precedent from St. Kitts and Nevis, which supports Dixon's case, citing a 2019 matter involving an accountant who successfully challenged public service rules that barred him from political involvement unless he resigned. So as I said, this is new to me, that the application of the rule may be unconstitutional and that Dr. Dixon's rights may have been breached, and that this is an undesirable state of affairs, and that the health ministry, according to these gentlemen, the two attorneys, John Clark and Matondo Mukulu, they move against Dixon to interdict him, breaching his rights, and that he has every right, the gentlemen are saying, to the action that he took to remain in the public employ while seeking political office. I find that to be curious because there have been several cases in the past where a person who's in the employment of the public service, who's seeking political office, resigns. Horace Chang will tell you that it happened to him in 1980 when he was employed in the public sector and he was seeking political office. He resigned. The PNP took issue with Tova Hamilton in the run-up to the 2020 election, saying that given that she worked with TPD Co., she shouldn't be seeking political office against Victor Wright in North Trelawney. And they also raised the objection. In fact, the PNP wrote to the political ombudsman about Tova Hamilton. They also wrote to the political ombudsman about Rhoda Crawford in central Manchester, saying that, you know, these two people are employed in the public service, and especially in the case of Tova Hamilton, who they said was able to call on resources from the TPD Co to help her bid to unseat Victor Wright, that she shouldn't be allowed to go because she had breached the public service staff orders. In fact, further than that, there was a court matter in 2018 where the Supreme Court voided the election of Dean Jones, the JLP counsel for the Yalos Division. Chief Justice Brian Sykes, who handed down the decision, the Gleaner is reporting, ordered that an election be held in the division in the shortest possible time. The decision to disqualify Jones came after Justice Sykes found that he was a public employee at the time of the local government elections in November 2016. So there's a precedent for the court ruling that you were in the employ of the public service at the time of your election. So the election is voided and you have to run it again because you were ineligible to stand given your status as a serving public service employee when you ran for the election. That happened in 2018. Robert Morgan, North Central Clarendon, 2018. The president then of the Jamaica Civil Service Association told RGR News that given the announcement that Morgan would be seeking to enter representational politics, he must step down from his post at OPM. Grant said, quote, "The rules of the public sector dictate that if one is going to go onto a political platform, then one has to resign their public office and pursue those alternatives that you are seeking." Grant explained that the rules apply even if a worker is engaged in a contract. Yeah? Then, 2024, the Health Ministry issued a statement. Workers in the Ministry of Health and Wellness are being advised that it is against the public services staff orders for employees to engage in representational politics and must quit their jobs if they plan to do so. So this was in 2024. Yeah, the Permanent Secretary Errol Green says the ministry has taken note that certain employees in the different regional health authorities have put themselves forward to represent political parties in the next general election, which is due next year. He noted that this is not allowed, citing the staff orders which state that officers are expressly forbidden to engage in any type of partisan political activity in any elections at any level. That was made, well, in my view, made clear in 2024 that you have to resign before you so proceed to representational politics. So it appears as if Dr. O.J. Dixon kept his job in the public service as a medical doctor, went for the election, was unsuccessful, and intends to carry on as a medical doctor. And the health authority, Southern Regional Health Authority, is saying, no. This is not right. This is a breach. And the two attorneys, John Clark and Matondo Mokulu, are now saying that Dr. O.J. Dixon's constitutional rights have been breached and that he should be free, notwithstanding the staff orders, to do as he did. So what do the staff orders say? Staff orders for the public service 2004. This was actually signed by the revised orders, which took effect from August 1, 2004, signed by the then Minister of Finance and Planning, Dr. Omar Davis. When you scroll through the contents, you look for 4.26 under Code of Conduct. Yeah? So 4.26 under Code of Conduct of the staff orders. And it speaks to the same issue in dispute. It says, political activity. Officers are expressly forbidden to engage in any type of partisan political activity in any elections at any level. That's part one. Part two, in the exercise of official duties, no service or benefit should be denied or provided to anyone on the basis of partisan political affiliation. And in the exercise of official duties, officers may be required to provide factual information to explain or clarify government policy. So 3 parts to political activity. The relevant part is part one, which says officers are expressly forbidden to engage in any type of partisan political activity in any elections at any level. The operative word there, in my view, is officers. You can't be an officer at the time that you're running in an election. You'd have had to be an officer. It's okay to be an officer before. But at the point where you are a candidate, you are nominated, you can no longer be an officer. And in my view, the rules are clear. So I don't know how these gentlemen are saying that there's an issue of constitutionality and that Dr. Dixon's constitutional rights were breached. So the Supreme Court then would have erred, and these things are possible. The Supreme Court then, by the reasoning of John Clark certainly, and Mukulu, to disqualify Dean Jones after he won in November 2016, well, that was a wrong decision then, because clearly he was acting within his constitutional right and he should not have been barred. But the Supreme Court has set that down as part of the precedent. Yeah? Then, the question that Mukulu asks about, the fact of a doctor being interdicted, well, it doesn't matter what profession he holds, does it? And he asked whether or not the salary issue, that is a breach, because he says the staff orders will not and cannot pass the constitutional test set as it relates. It cannot be shown that interdiction is a proportionate tool, with its adverse impact on a person's salary. Remember, O.J. Dixon and his representatives will go to a meeting with the ministry, and there they'll discuss what proportion of his salary he will lose. He could lose 1%. He could lose 90%. He could lose 99.9%. Yeah? He could just get a little shave. So would that be a proportional issue to say, well, the fact that he breached the staff orders in this, because clearly, based on the evidence on the table, he has breached the staff orders. So I don't see all of a sudden, there have been so many instances I've cited in the past where persons have been cited rather for breaching the staff orders. Man has gone to court and lost the seat that he won in an election because he breached the staff orders. What is so special about this instance now? What attends to these circumstances where O.J. Dixon is concerned that will make him immune from the rule that has been applied to several others before him? Gentlemen, I wish you could elucidate.